All right, I'm going to be very quick, guys, because I know we're running behind, and we were supposed to do door prizes like 15 minutes ago. All right, so as Charles did not tell you, my name is Matt Eichelberger. That one's not on. Okay, I'll use this one. All right, so I was just talking to Charles a second ago. I do act as the attorney for the coalition, so obviously there's some issues that arise from time to time with any organization, and I help you all out with those. I practice in Jackson and all over the entire state. This was a very rainy week across Mississippi. I know because I was up driving in it before the sun every day this week except this one. We're literally all over the state. And I practice primarily criminal defense. The other thing that I do is I do a little bit, tiny bit, of civil rights work that arises out of the criminal justice system. Think police brutality cases, think jail beatings, those types of things. Now, I have to qualify that further. They have to be catastrophic injury cases like death, serious permanent disfigurement or disability, traumatic brain injury, those sort of things. So that's what I do. Now, I was talking to Charles a second ago, and I was reminded of something. So many moons ago, I had a client that Charles had bonded who skipped town and skipped the country, went across the border in Mexico, went way south, was almost to Brazil when he was found out and hauled back here. And it occurred to me that that is probably a fear that all of you have kind of deep down there, is what happens if they run across the border? And you've probably all had those stories. But how many of you have actually crossed the border in Mexico? Like, not been to Mexico, but actually from the southern United States crossed the border? Let me see a show of hands. 2, 3. Did you drive across or walk? Walk, drove, drove. Okay. You know what I'm about to say, I think. So back when we were all younger, before 9/11, you could just cross the Canadian border or Mexican border with a driver's license, and that was it, right? And then after 9/11, they shut that down, or at least they told us they did. So I'm in El Paso here back in April for some depositions on a civil rights case. And they end early. I've got some free time. I did not bring a passport. I just wanted to see what the border looked like. So I walk over there, and I'm looking at the border, and I'm talking to these federales who are like, no, you can just come across. It's fine. You can come across. They'll let you back in with a driver's license. Well, the lawyers there in town had told me, no, you need your passport. Everything I saw online said, no, you need your passport. I said, thanks, and I walked back to the hotel because downtown El Paso is literally on the border. Like, it's absurd how close it is. So I get back to the hotel. I asked the bellman. He says, you got to have your passport. Well, I decided to call. So I called CBP, and they said, look, you're an American citizen. You can come back across with your driver's license. So I beat feet down to the border again, and I walked across. Do any of you have any clue what it takes to walk across the border from the United States to Mexico? Because it does require something. 50 cents. That's what it takes. There is no driver's license check going across. There's no identity check going across. You walk through in basically like this little hovel. You go across the bridge, and then you walk in through what looks like an airport scanning facility somewhere in French Guiana, okay? I mean, we're talking, there is a metal detector, and that's it. That's it. Nobody stamps your passport. Nobody asks who you are. So yes, it is really easy to cross the border there. Now, I would probably rather go to Parchman than have to spend a night there in Juarez, because it's a pretty awful place. But you can cross that easily. So just bear that in mind. It's extremely easy to cross the border over there. Now, on to what I'm here to talk about. Okay, so last year I gave you a legislative update. I think most of you are aware of the big change that happened this past session, the 2025 session, went into effect in July. It was 2315. That was the bail reform legislation, set aside orders. Now the clerks have to accept them when you weren't notified, right? There's a big notice change in there. It clarified bond discharge. It was just kind of amorphous before, right? Like, I don't know when you're discharged. Well, they actually set out now in statute when you are. NCIC entry wasn't always being done, and now that's required by law. And then finally, there's some provisions, some safety provisions in there for the Department of Insurance license revocation. So if you ever wind up in any of those situations, know that the new law does apply to you. There was a little bit of action this year in the legislature. There were 5 bills that were presented, okay? None of them passed. One bill wanted specific judicial findings before bail could be granted in violent crimes, and then removed from justice court the authority to set bail in felony matters. So that would be a big change, because right now, justice court judges can do that and do that frequently. I think that would probably slow things down. Just as a practitioner, if we had to wait for a circuit judge to set bail in every case, that would probably slow down that entire part of the system substantially, and that's probably why it died in committee. Additionally, there was some legislation that did pass out of the Senate, and that was to allow for y'all to recoup credit card processing fees. Small thing, but adds up over time, right? Because there's some ambiguity as to whether or not y'all can actually do that. It passed out of the Senate. It died in the House. I think that was just because it didn't have time. That's something I anticipate will go through next year. There was kind of the flip side of the Senate bill where they would remove the ability for justice court judges to set bail. Over in the House, they think that's a great idea, and they wanted to give justice court judges the ability to set bail in capital offenses, which they don't currently have. So there's kind of a flip side there, and that one passed the House. So that is an overview of kind of what's going on there. There was a companion bill to the House bill that passed out about the justice court judges and capital offenses. It died really quickly in committee over in the Senate. And then there was also a proposed constitutional amendment. I've saved this one for last because I think it's probably of most interest to y'all. Currently, there is no prohibition against a judge allowing somebody to be released on their own recognizance in a felony matter. Okay? Now, judge probably wouldn't do that if they want to get reelected, right? But if somebody comes in on an auto burglary, Judge Kidd could just write an OR if he wanted to, or a justice court judge in Harrison County could do that if they wanted to. There's no prohibition against it. Well, there is a constitutional amendment that was offered up last year in the Senate that would have prohibited that practice, that every felony charge would have to be accompanied by a bond. So that, in terms of just general public safety and the orderly administration of justice, is probably a good thing. I don't know how much we're actually seeing those in practice, right? Are y'all seeing that, where people are being OR'd on felonies? Yeah? Seeing that some? Okay. Well, this would shut that down. Now, bad news is that died. It really got nowhere. But to me, sounds like something that might gain a little traction and be attractive to legislators. Okay. There was also, and I'm going quick as I can here, I probably took up too much time with my Mexico story. Let's see. I'm going to skip those. I'm going to get to another personal story, but I think it's something you're all dealing with. So I was in a justice court in a county that will remain nameless here a few months ago. And after a felony prelim, the judge ordered him back into custody, not because he was raising the bail. All he did was he found probable cause, as had already been established through the warrant, right? Nothing had changed. He ordered him back into custody because he was going to require that the bondsman rewrite the bond returnable to circuit court. How many of y'all are seeing this in practice? Yep. Okay, so it's not a one-off. It's happening elsewhere as well. Apparently what happened, because I asked the Justice Court judge what on earth he was doing in a very nice way, because this was strange, and I've been doing this 23 years, I've never seen it. And he said that he had been at judicial college, right? At judicial college training, they had told them that's what they were supposed to do. I said, really? Well, where did this come from? I've never heard about this. And he said, I don't know. There was some guy there telling us about it. I said, okay, all right. And I'm not going to name him. One of y'all. He was there just touting all this knowledge about it. Well, here's the problem. The Mississippi Supreme Court, back in 2017, finally released the Mississippi Rules of Criminal Procedure, all right? And they deal specifically with this issue. We worked on those rules for 3 straight years before they unveiled them almost 10 years ago now. Rule 8.7a says this, that if somebody is out on bond prior to indictment, if there is an indictment, that bond shall be recognized and transferred over on the same charges, lesser charges, or related charges. And there's probably some room for litigation from time to time there on related, but that is an answered question. So if you're seeing this, if they're making you turn around and drive, 20 miles, 30 miles out of the way to go rewrite a piece of paper because some justice court judge has it wrong, now you know. Tell them to look at Rule 8.7a. That is absolutely unnecessary. The other way around that would be to always write the bond in the first place returnable to circuit court. I like just pointing them to the rule because that's going to fix any issues you have. Now, speaking of issues, how many of you have had problems? How many of you write in Rankin County? Most of you. All right. You know what I'm about to talk about. So Judge Ratcliffe, I don't know exactly why, if it was him, if it was Victoria, I don't know who started this up, but these bail check-ins, right? You got to go check in every month or every other month now, or whatever they're changing it to tomorrow. You got to go check in to see if you've been indicted. Now, that works in smaller counties. In Simpson County, they're not but a couple dozen people, a few dozen people that have to show up, and they all have to show up a few times a year. Well, in Rankin County, you got hundreds, if not thousands, and they're scattered across the United States because they love to arrest people with out-of-state tags in Rankin County, right? And then on top of that, those cases sit, and your phone rings nonstop now for a week prior to that deal, and you're worried, are these people going to show up? Well, it happens to us defense lawyers too, because somebody gets picked up on a drug case out of Flowood or wherever, they're not going to be indicted for 18 months because the crime lab's back up. I know that. Y'all know that. Everybody knows that. But they're going to have to show up 18 times from North Carolina or California or New York or wherever. So there's been some bending, I think, on some of that. But that said, there was a lot of question as to, well, what's the authority for that, right? Like, can Judge Ratcliffe order that? And the answer is maybe. There is some there's a real interesting way to read the foundational statutes of bail, right? And it's returnable to court. These check-in proceedings are not hearings. They aren't any sort of formal court process that I can find or that anybody can find anywhere in any approved court rules or in statute. So the question is, can they do it? I mean, yeah, I guess maybe. Maybe. Would the Supreme Court tell Judge Ratcliffe or any other judge, no, you can't? The Supreme Court? Maybe, probably not. Are you going to find anybody who's going to go piss off one of these judges raising that point with them? No. No, you're not going to. So we're going to have to live with it for a while until they find it to be just, I think, too cumbersome. All right. That's enough out of me, unless y'all have a question about what I just talked about.
Isn't there a Supreme Court rule, though, that once out on bond, that you have to report to each grand jury session?
Not to my knowledge. No.
What was the question?
Isn't there a Supreme Court rule that says you have to do that? And I don't believe that's true, no. I'm sorry, hit me. I'm not sure I understand that question. I haven't heard about this rule. Oh, okay. So this goes back to regulation of bonding ability, right? And ultimately that goes back to the sheriff. And they do have pretty broad authority. I don't necessarily like that, especially in light of this situation they've created with these bond check-ins, right? I think it shows a little bit of a misunderstanding of the pre-indictment phase of a criminal case, and what the reality is of those prosecutions, which is understandable when you look at the district attorney's office. They don't do anything until they get the file, right? They're getting a completed file from law enforcement most times. The judge doesn't see it. Judge Ratcliffe doesn't see it until it is indicted. Judge Ratcliffe was a county court judge prior to that, and prior to that did not practice criminal law. So I'm not sure, and this is not a slight against him, but I'm not sure that he has a full grasp of it either. And I don't know that the sheriff himself really understands the delays that are attendant in especially drug cases. So I think the rule's terrible, but the sheriff has the ability to do it. You know who doesn't have the ability? The circuit clerk. I've had that issue come up before.